You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diament, founder of Diament Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diament.
Hello and welcome to the Patenting for Inventors podcast, episode 131. Can I patent a card game? My name is Adam Diament, a registered patent attorney and founder and owner of Diament Patent Law in Los Angeles, California. I can be contacted through my website at diamentpatentlaw.com. That's D-I-A-M-E-N-T, patentlaw.com, or you can call me at 424-281-0162. In the last episode, I talked about patenting a board game, and many of the same concepts are involved with whether you can patent a card game. The short answer is yes, you can patent a card game. Again, your card game has to be new and non-obvious, and now usually in board games, you have a new kind of board and new pieces and rules that go along with the board and pieces, and I talked about all that in the previous episode. For a card game, if you're just using a standard deck of cards and you want to patent rules for a new game, there's a good chance you'll get a rejection on the rules of the card game just being an abstract idea. Remember, you can't get a patent on purely an abstract idea or mathematical formula. And this is especially true given a court case that came out several years ago called In re Smith from the Federal Circuit in 2016. This involved a patent application for a blackjack variation that got rejected. And if you want to look it up, it's U.S. Patent Application number 12912-410. The inventors came up with a new way of playing blackjack, but it involved a standard deck of cards. There are 9 steps of this game in the patent application labeled A through I. I'm not going to go through all of them, but they involved shuffling a standard deck, dealing it in a certain way, and additional bets are made along the way, and the additional dealing that it's different from the normal rules of blackjack. The court said that the particular physical steps, such as shuffling and dealing, are conventional elements of card gambling and therefore insufficient to transform the claimed abstract idea into a patent-eligible invention. The court also said that it's effectively a method of exchanging and resolving financial obligations based on probabilities created during the distribution of cards. Now, this case came after a couple of cases that are the bane of every patent attorney's existence, called Alice and Bilski. In Alice, the Supreme Court held that a method of exchanging financial obligations was an abstract idea and not patentable. And in Bilski, the court said that a method of hedging risk was also directed to an abstract idea. Basically, it made it much more difficult to get patents on business methods, and the courts are still trying to figure out what's patentable and not patentable. But regarding the card game, the court said that just shuffling and dealing the cards wasn't enough to make the card game patent eligible. But the court did specifically say this doesn't mean that all gaming is ineligible, and they gave an example of using a new or original deck of cards. So if you do come up with a card game that you want to patent, at least if you want to follow the current law, and who knows, it may change because patent eligibility has always been challenged. Don't plan on getting a patent if it's just new rules that you're doing. Make a new deck of cards. You can always file a patent application for just your rules of playing a card game with the regular deck, and who knows, by the time it gets examined, maybe the law will have changed. But until then, expect a rejection that will be difficult to overcome, and think about coming up with some new kind of card deck. Another way that you might be able to get around the patent ineligibility rules is if you link up your game with something such as a computer or some other physical system. Because Claim 21 of the application, it was directed to the same method and rules, except instead of it being a physical card game, it required a video gaming system that used a processor. And this was found to be patent eligible. So besides just a new deck of cards, if this is something that can be played on a computer, it's just an added little thing that might be able to get you over the hump of patent eligibility. If you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamentpatentlaw.com. I'm Adam Diament, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast. For more information and help with your own intellectual property needs, contact Adam Diament directly by going to diamentpatentlaw.com. That's DIAMENT patentlaw.com. Or click the show links to connect by phone, text, or social media. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.